All right, welcome everyone, and thank you for joining us. Today's presentation is navigating PBM terminations and Board of Pharmacy risks in 2026. I can't believe we're only a few weeks away from the new year. My name is Eric Knowles. I am a partner in Frier Levitt's pharmacy practice group. There I am with a questionable shirt tie combo, which you know, I'm usually a more snazzy dresser than that, but hey. During today's session, we have some learning objectives, and here's what we want to cover today. All right. We're going to want to understand Board of Pharmacy inspections, PBM obligations, and how to manage both effectively. We're also going to be able to identify common audit deficiencies that lead to Board of Pharmacy discipline and/or PBM terminations. Two very important topics. We're going to learn best practices for self-audits, policy updates, and documentation. We're going to explore legal and appeal options to challenge PBM or Board of Pharmacy enforcement actions and apply proactive strategies to stay compliant and protect network access in 2026. So it's going to be both reactive and also proactive. So that's the goal here. What to do if a PBM or Board of Pharmacy sends you a particular notice or particular inspection or investigation, and also these proactive strategies, which are also extremely important. But before we get started, there's a few housekeeping notes that I want to cover. This webinar is being recorded, and you'll receive a link to access the on-demand replay in the next few days if there's something that you don't catch, or if you're watching this on demand, welcome. And today's discussion is for informational purposes only. You can see the disclaimer there and is not to be construed as legal advice. If you'd like to speak further about your specific situation, our contact information is going to be provided at the end. If you have any questions during the presentation, please submit it through the Q&A tab, which you'll see, and ensure your name is visible so we can follow up if we're unable to address your question live. But even after the session, I'll be sure to address each and every one of your questions, whether it be via email or some other form of communication. We're going to answer as many questions as time allows. But if anything comes up afterward and you don't think of it during the session, we encourage you to reach out at any time. But with that said, let's get going. So Frier Levitt, we are a boutique law firm, and all we do is healthcare and life sciences. This is our 25th anniversary, which we're very proud of. And we use that term boutique proudly. Our goal is always to have very personalized and individual relationships with our clients. And the fact that we're really a provider firm, I think, just speaks volume to our mission. And I'm just really proud to work here. But on to the topic of the day, all right? This is the anatomy of Board of Pharmacy audits and inspections, right? So Board of Pharmacy is coming to your door. Why are they there? What type of audits or inspections are there? So first, there's the routine compliance audit, and this is just periodic inspections. They can be reviewing really anything. So just because the Board of Pharmacy is at your door doesn't mean that they're looking for something specific that's wrong. It could just be you're due for an inspection, right? The Board of Pharmacy hasn't been there in a couple of years. They're like, what's going on with Larry's Pharmacy? We're gonna go stop by, take a look what's going on. They're often unannounced. It's rare for them to say, hey, we're going to be there next Tuesday. So, I'm sure a lot of the people on the call have a lot of experience with this. Not always the most welcomed visitors to the pharmacy, especially from the clients that I speak to. But, one of the goals today is to feel confident once they're there, that you're complying with the various regulations in your particular state or federal regulations. There's also targeted or complaint-based audits, and this is when this is when there's a reason why they're there, right? It can be something along the line of a consumer complaint or patient complaint. There's a particular patient that, let's say, had some effects from a particular medication, and they're alerting the board. And now an inspection is opened up, and the board wants to learn more, not only about this particular case, but they want to, they can then dig into to other things at the pharmacy. There's also PBM complaints to the Board of Pharmacy, right? PBM audits a pharmacy or investigates a pharmacy. They have certain discrepancies that pop up during their audit. They alert the Board of Pharmacy, which can then start an inspection. And a part of what we're going to speak about a little bit later is to just really be cognizant of that communication that can go back and forth between a Board of Pharmacy and a PBM, and really understanding that even though a PBM, for the most part, is a private organization, they do speak to various government entities, including the Board of Pharmacy. There can be a DEA referral, federal matter, where the DEA, they they are alerting the Board of Pharmacy of a particular issue that they see, to then really have more boots on the ground in a particular state to look further into an issue that they think that is going on at the pharmacy. There's law enforcement. Anyone on this call will be aware of, let's say some type of criminal complaint against a particular pharmacist at a pharmacy. Let's say that there was a break-in at the pharmacy, and you did the right thing. You told the police, right away. But now the Board of Pharmacy wants to come in and check and see if the pharmacy had the right protective measures in a scenario like this. Also, if there's a regular data reported to state reporting systems, that could trigger something. So there's a lot of different rhymes and reasons why there's a targeted complaint. And this can trigger, obviously, an audit to look for anything else that the board will want to dig a little deeper into. There's also change-related audits. That's conducted following a change in ownership, change in location, change in PIC. It's very common, especially in a change of location, for the board to want to look at, all right, well, what's the new layout in this particular pharmacy? And obviously, this is very common in the compounding pharmacy space. We want to take a look, make sure that they have the right equipment. Are they moving into a bigger facility, smaller facility? They want to look at where the drugs are housed. And so, that's just a common reason why a inspection may begin. So on-site inspections, right? So the Board of Pharmacy is physically at the pharmacy. So they're going to be looking at certain things, right? We were talking about the physical premises and security. One common thing that I see a lot is verification of licensure display. So this could be pharmacy, pharmacists, technicians, DEA registration. So like, even if your technicians, all the registrations are up to date, it's very common for inspectors to take issue with, let's say, a technician's license is not adequately displayed. The pharmacist's license isn't displayed according to the regulations. So it's important to not only understand, it's that you need to obviously be up to date, have your licenses renewed for all of your people at your pharmacy, but also that they're displayed properly. They're going to be looking at, your storage conditions. A big one is always the refrigerator. Is it kept to the certain temperature that's necessary for that particular medication? Do you have a temperature log that you're keeping? Do they have which will provide data for the Board of Pharmacy to review. Security measures we mentioned. What's your safe like? What's your camera system? So all of this stuff is obviously very important. You know, they also want confirmation that expired, recalled, or returned drugs are segregated and are disposed of. So that's obviously also very important. They're going to be looking at your record keeping. They're going to be looking at your inventory. Do they line up? Do they match? They're going to be making sure that all of your logs are up to date. Are you doing the correct reporting? So are the logs properly signed? They're also going to be looking at prescription processing and labeling. They're going to be reviewing labels for accuracy, legality, and completeness, so that they can just take a sample of particular product, and they can review that. If something looks off on one particular medication, it can trigger them to trying to look for other examples. You know, and obviously this is huge in the compounding space. They're going to be, making sure that you're compliant with USP 795, 797, and or 800, depending on, what your pharmacy does, and what you're trying to accomplish. So, um, and they're going to be looking at personnel and supervision. They're going to be, they're going to be they want to make sure that a PIC is properly designated, and even if the inspection isn't on site and you're licensed in particular states, it's important to really understand what states require a PIC to be licensed in that particular state, or do they just need a pharmacist licensed in that state? Does it have to be a designated PIC? This for bigger operations, it's really important to understand the various state laws. You're going to be one to have handy and be able to review training documentations for technicians and interns, and this usually falls on the PIC. There are states that require the PIC to train technicians, to keep a particular binder or book for technicians to refer to. And as a PIC, it's a heavy burden. And when I first started, practicing pharmacy law, I was surprised at how heavy certain things fall on the shoulders of the PIC, and how the Board of Pharmacy makes them liable for so much. So, you know, it's an absolute admirable job and position, but you have to understand the risks and make sure your people are properly trained. And that also goes with policies and procedures, right? The board might want to inspect, all written policies and verification that there's, you know, different quality assurance. And this comes up a lot. Let's say the Board of Pharmacy comes in, finds certain discrepancies. They want to look at your policies. They want to know, well, what was in place, right? Was something in place that applied to this particular issue? That they're looking into, and was it followed properly? Were these particular individuals trained on this particular policy? It doesn't mean that that policy has to be set in stone, if there is an issue, but it's important to have these policies and procedures to at least say, hey, we understand what the regulations are. Someone might have deviated from those, but at least we have a policy in place. And we're going to get into some corrective measures a little later, but it's also important to understand that you know the, that it's important to have this dialogue with the board that, all right, we have this policy and procedure, we see what you're saying, and we're able to update that, and we're willing to work with you. Audit findings and post-audit review. So this is kind of how, you have the inspection, now there's some audit findings, right? So the inspector where investigator discusses the preliminary findings with the PIC. There's usually some type of sit down. Sometimes those reports are generated very quickly. And they'll sit down and the inspector will identify alleged violations and will usually require some corrective action there, right? And they'll usually give, depending on the state, between 14 to 30 days to either respond or correct those deficiencies. Now, the difference is when I say respond, responding is saying, you allege this particular discrepancy, but I disagree here that it was a discrepancy. Here's why. I understand maybe why you could think that, but no, we actually have a temperature log for our refrigerator. Our apologies, it just the particular individual who was there at that moment when you were asking for that, inspector, just didn't have it at the ready. Here it is. And also, correcting deficiencies, right? You're also given the opportunity to correct certain things that the board deems to not to be in complying with that particular state law. And here's some common deficiencies that I see a lot. Missing or outdated biannual controlled substance inventory records, right? It's not that you really have any miscounts or anything. You just your records might be outdated, or they might just not be ready at that particular moment. I've seen, it's a very stressful situation, and I really want to be sympathetic to the human element here when there's an inspector in your office, in the back office, or talking to a PIC, or they're there with the drugs at the particular pharmacy. Um, you know, it, it's just a common one I see. There's late reporting at times. Expired drugs stored with active stock. Just always check your expiration dates. As much as you can. We find that particular pharmacy software is an effective tool for this. If you're a little more old school, and you do the eye test and try to look at least, if you can, bi-weekly, weekly, just to make sure you don't have any expired drugs on stock. The reason why that's so important is that if a particular inspector finds some expired drugs on your shelves, it could go to patient safety, and then they can make that leap, right? Well, what would happen if somebody walked into the pharmacy? Like an experienced pharmacist would most likely catch this, right before they look at a particular bottle and before they gave it to a patient. But at the same time, you just don't want to be in that position. I've also seen technicians, a lot of allegation of technicians working without active registration. This can happen a few different ways. You hire somebody to be a store clerk in the front, or check people out, and you're it's gradually they start kind of maybe just doing some minor tasks that you think they're not a technician, but they can help out a little bit in the back, just grabbing a particular pill bottle, or the further and further you go down that road, it's more likely that an inspector can interpret that as someone working without an active technician license. All right. Failure to document certain type of counseling. A lot of computer software allows you to take various notes, and it's easy to be an armchair quarterback as an attorney looking at this later. Well, did you take any notes? It's best practice to document as much as you can. So now, post audit review and enforcement. So typically a board of pharmacy compliance department reviews the inspection report and corrective actions. So you've had a chance to speak to this particular inspector, and you kind of go through the inspection report. You file a response. You detail your corrective actions. And here are the outcomes. Everybody, you're going for no action, right? Your response was adequate. You show that there were no violations of any type of regulations, or if there were some minor regulations, right, you were able to just demonstrate corrective actions. And now there's no action. The board says, okay, the inspector says, all right, the compliance department says, okay, we hear what you're saying. We're not going to take this any further. They might even say, all right, we please consider, you know, what we talked about and move on from there. The next one down the line is a warning or corrective action letter. Various states have warnings. They're either called letters of warning, things like that, where it's not any type of formal discipline, but usually the board will keep this in their own file. If they come back again and maybe they find something down the road, they can refer back to that for particular warning. There's also a referral to the board's enforcement section. So now, you're likely to be dealing at this point with a board attorney of some type. This usually, again, occurs for repeated or significant violations. And then finally, you're dealing with some type of administrative action. So you have the complaint now. You're dealing with a board attorney, and you're given some type of notice, and you have an opportunity to either, you have some difficult decisions ahead, right? You can either maybe go toward a hearing, you can agree to some type of fine. The board might be proposing some type of probation, suspension for serious offenses, or even a revocation of a license, unfortunately. And these are all obviously very serious at this point. It's just kind of how these things progress. If allegations are serious and a pharmacy is not able to show that they've corrected any type of alleged deficiencies. And, I'm talking about being an armchair quarterback, and it's easy, and I know everybody is extremely busy. And, a lot of feedback that I get of having a webinar, like this is live at 12:30, is we're extremely busy, and it's hard for pharmacists to attend a webinar in the middle of the afternoon. And I know how busy you are when I go to conferences for pharmacists. It's usually on the weekend, and that makes total sense, especially in the community pharmacy world. But with that said, self audits can prevent infractions. All right, if you can find the time, like quarterly spot checks really are a pharmacy's best tool to prevent both Board of Pharmacy and PBM scrutiny. It's important to verify licensure, registrations, controlled substances, inventory, and labeling accuracy. And it's important really for license and registrations, as I was saying earlier, across all states in which the pharmacy operates. Once you get into that, you're in 10 different states, and you're not really sure which laws apply in this state or this other state. It can get complicated. Again, you want to ensure that licenses are properly displayed. If you're in your pharmacy, you should, take a look at the pharmacy and say, if an inspector or investigator came into my pharmacy, would I be confident that we'd pass and there'd be no action against us? You want to make sure that you're up to date on your controlled inventory variances. You want to keep purchase and transfer records, in a uniform binder or e folder system. It's really important to know what your inventory is, not only for controlled substances, especially for pharmacy benefit managers, if you're doing a lot of claim submissions and they say, okay, we want you to prove that you had sufficient inventory to justify your claim submission. So the PBMs are going to be asking for records directly from your wholesalers, but you want to make sure that your records are up to date and match that, right? If you're transferring product to and from a particular pharmacy, please, you want to do that in writing. You want to have accurate records of that because it could really throw off maybe your count of a particular medication. Here's some additional factors determining discipline that boards weigh when determining whether discipline is warranted. They're gonna check your history of noncompliance, and I mentioned that when I was talking about like a warning letter, if you get a warning letter, or how they keep track of a warning letter down the road. Repeat violations or failure to correct prior deficiencies are the worst. We you a particular technician's license wasn't properly displayed. They come back a year later, a different technician's license isn't properly displayed. Yeah. This goes in revert and on the other side of the coin too, right? Like a strong compliance history and prompt corrective action, may result in a warning letter or advisory letter in lieu of formal discipline, right? Like, when I'm writing response letters to a board of pharmacy, it's obviously much more effective if I say this pharmacy's been open for 15 years. It's never been disciplined by this board or any other board. Um, Cooperation and corrective action, good faith cooperation. The board of pharmacy world is, I don't want to say strange, but different. If and I say that in if I'm going to compare, let's say, if I'm defending a criminal client, you have a right to remain silent, but you don't really want to, give any information to a police officer. You don't want to volunteer any particular information. The board of pharmacy world is much different. From my experience, good faith cooperation and having an open dialogue with the board is very effective for navigating these issues and for really, showing your respect and deference to the board. It goes a long way. Especially if there are corrective measures that you're taking, board, we hear you. Here's what we're doing in the immediate, like right now, and here's what we're doing in the immediate future. Here's an updated policy that we have on this particular subject. Um, here is a affirmation page. Look, everybody that details each and every member of our staff that's been trained on it and on what date. But if there's evidence of intent or recklessness, the board is going to come down, pretty hard on a particular pharmacy. Recklessness and the disregard for the public is something that, as you can imagine, is frowned upon. But it's still important to not ignore certain board requests, to be cooperative to the extent possible. So I have a three-step disciplinary process, which we've been talking about. So you're going to get that written notice. This document's going to set forth the allegations and proposed sanctions. And your pharmacy is probably going to be given around 30 days in most states to formally request a hearing. And if you are at an administrative hearing, and that's necessary to try to resolve something, if you're not able to come to a resolution, either with the help of counsel or, you know, or on your own accord, depending on how you want to handle this. There can be an administrative hearing, and administrative hearings with boards of pharmacies. I'm making that comparison from criminal law. I made that a little earlier, and I'm going to do that again. You know, it can a lot of these board hearings are conducted before a board officer, which can put a pharmacy or a pharmacist or technician that's before the board at a significant disadvantage. It's really 2-on-1. So you're going to have a board member or a panel that would serve as, let's call it the quote unquote judge. And there's going to be a board attorney that is going to be presenting evidence. Their witnesses are most likely going to be investigators, inspectors, who are going to authenticate various evidence. They can have a patient complainant who filed the initial complaint. And this is a stage that you're at. Or if you think it's necessary because the board offered some type of deal to avoid an administrative hearing that you just couldn't accept, like they're offering you like revocation of your license. There's like a lose-lose, like why it's something that you feel like you absolutely need to fight. I think it's imperative to really think if you need counsel at this point, because at least counsel is going to be able to present evidence, cross-examine these board witnesses. You're going to be at a disadvantage, but some states are before administrative law judge at least, where I think you're going to get a fairer shake at that. And then, from there, there's going to be a board decision if you go down this road. The hearing officer, the administrative law judge, or the panel, they're going to make the decision on this. And then the board most likely is going to vote in a public meeting on the final disciplinary action. The disciplinary action could be a reprimand, probation, monetary fine, suspension, even that revocation, which I mentioned before. The boards of pharmacy tend, if you go down the administrative hearing route, the final disposition is most likely going, and if you're found to be in violation of the allegations that are before the board, it's most likely going to be a more severe penalty, and you can understand kind of why that is. They give you an opportunity in the beginning to take a certain resolution, but if you go down the administrative route and the lawyer needs to prep, the board has to make a decision on this. The you know it's possible that you might get the same resolution as you would have if it was a negotiated one, but odds are that it might be it could be a worse penalty. But that doesn't mean to say that you shouldn't hire counsel and fight something that is if you know that you have defenses for, and if it's something that you absolutely the allegation is false. But it's important to really dive into the allegations early on. So here's the role of legal counsel in Board of Pharmacy and PBM matters. Attorneys with experience in Board of Pharmacy actions and PBM terminations can minimize disciplinary action by providing guidance during an investigation, right? If you feel like an investigation is conducted, and this is just way over your head, and you really need a competent attorney with experience in at these early stages. The legal counsel can serve as an intermediary to ensure responses if to the board are accurate. You don't want to make any inadvertent admissions. So it's important to consider. Oh man, these it looks like the board is alleging something serious here. I'm giving an opportunity to respond. You got to think, do I feel confident that I will give the correct response without maybe saying too much, saying too little, and striking the right balance? And it's important to develop a defense strategy early. Counsel can identify evidentiary deficiencies, maybe some certain procedural irregularities. Maybe the inspector didn't do something properly. And we're always looking for certain mitigating factors that could warrant dismissal or reduction of the charges. And you know, it's counsel can also be a great tool to negotiate certain outcomes. If a counsel has experience, I've dealt with this particular issue before. What is a reasonable resolution? What are the proofs here? What are the defenses? What are the strengths and weaknesses of a particular case? And counsel can also manage reporting obligations, right? Let's say you want to negotiate an outcome and you want to, just pay a fine, but technically it's a disciplinary action by the Board of Pharmacy. You have to think of, all right, well, what are my reporting requirements? Who do I need to report to? How many states am I licensed in? Can I wait until recredentialing in for that particular state to disclose this, depending on a particular application question? Do I have to do it proactively? And if I do, in how many days? This is also applicable to PBMs, right? So it's important to look at your contract and understand, all right, if I'm disciplined in this particular state, do I have to report this to a PBM or any other payer? So you have to understand your contracts, and a lawyer will help you. The more payers you have, the more states you're licensed in, the more complicated these things get, right? And it's also, a lawyer can help you protect your long-term business interests. I always try to communicate with my clients and understand, well, where do you get, the percentages of your profits from? Is it from private payers? Is it from Medicare? How long do you want to stay in business? Is this a pharmacy that you're trying to sell? These certain things can affect how certain matters are negotiated or resolved. And I mentioned this a little bit earlier, but there's an interplay between boards of pharmacies and PBMs. Non-disciplinary outcomes can still trigger PBM scrutiny if disclosure duties apply. All right, so just some matters are not resolved to a final resolution, but are made public. I've seen publications about certain med spas, and the Board of Pharmacy has inspected them, and then they release an article, right? Excuse me, the PBM got word of this particular investigation? It's important to understand your contract. How public is this particular matter, and is a PBM likely to know about it? Or do I need to, do you want to cover your bases and notify the PBM? Or do you even need to, according to your contract? So pharmacies should map their specific outcomes to their PBM contracts. So it's important to know when do you need to report things to a PBM. So here are the big contracts. Obviously, I know everyone's busy, but and these contracts aren't the most fun thing to read, to say it lightly. But you know, you, you should really review some of, at least from your largest payers, whether it be CVS, Caremark, Express Scripts, Optum Rx, Prime Therapeutics. And if you don't have a copy, you can request them. Try to be as organized as possible. If and this is more like the reactive, proactive thing we were talking about. If you can be more proactive and understand contracts to the best of your ability, it's also where counsel can come into play and help you. But if you have that general baseline understanding, it could really set you head and shoulders above some contemporaries who they know that they have a contract with CVS Caremark, but they have no idea what's in that provider manual or that provider agreement. And even though that you have a contract with a particular PBM, it's really important to understand that PBMs must comply with the law. They have to comply with both federal and state law in addition to the contract provisions. You know, it's important to understand how your contract interplays with various laws. Um, you know, uh, it's important to understand your rights. And even if a PBM says that they can do a particular thing, are they permitted to do so under the law? So here's some PBM contracts and reporting requirements. As you know, PBMs maintain networks through contracts requiring pharmacies to certify ongoing compliance with laws, regulations, and licensure standards. So here's some things that pharmacies uh, must disclose. Depending on the contract, though, these are things that you might have to disclose. Board disciplinary orders, potentially reprimands, or certain consent agreements. Again, it's important to look at your contract. If there's been any type of licensure restriction, like probation, suspensions, revocations, or even denials. So it's like you apply for a particular license, but it was denied. You didn't even have the license to begin with, but it's something that might need to be reported. And obviously, adverse actions by DEA, CMS, or Medicaid, DOJ, things like that. Those are things that are more on the national side, where PBMs most likely will be on their radar. Failure to disclose even inadvertently and especially intentionally may constitute a breach of contract. So that's that next level. So that kind of connects, like, all right, I didn't disclose a particular thing to a PBM. Well, the PBM might say, well, this particular section, you're supposed to notify us about a situation like this. You didn't do so, so it's a breach of contract. PBMs have broad discretion, including audits, recoupments, monetary penalties, and network termination. They have a lot of tools if they're finding certain things. PBMs often view regulatory discipline as a proxy for elevated compliance risk, for potential fraud or patient safety concerns. They learn about consent agreement with the board of pharmacy. It could then or a final consent agreement of some type. The board may review that particular consent agreement, see a particular issue. It could trigger its own audit. And these are some common PBM audit discrepancies that can be opened up either due to some type of board of pharmacy discipline, or, as you know, PBMs just audit pharmacies on their own accord. So something that we see a lot is a failure to collect copay, and this could mean a lot of things. It could mean there's a failure to collect copay outright. You just didn't collect it, or sometimes PBMs take issue with in the manner that you collected a copay. It's your particular credit card service, just didn't register something properly, or there's a lot of different ways that they can come up with that. The drug invoice shortage. It could be anything along the lines of you didn't buy it, you had the product, but you just didn't buy the product from the wholesalers that we say you're allowed to buy from. And they can, according to some contracts, they can state that, well, because you didn't have sufficient inventory from the wholesalers that we say you can purchase from, you didn't have enough inventory to support your claim submissions. Prescriber denial or patient denial is, something that we see a lot. It could even occur if a PBM investigator calls a patient, try to confirm something, and the particular patient doesn't respond, right? I've seen particular PBMs make that leap because they didn't respond. The patient didn't confirm that they received that medication, so it's a denial. Or in the prescriber side, you can imagine a busy doctor who doesn't want to be bothered by a PBM who's calling them. Uh, I know that a lot of pharmacies have great relationships with particular doctors, but doctors, for many doctors, not all, probably don't want to get involved in a dispute between a PBM and a pharmacist, and may not return their call, or just not really taking an active approach in support of a particular pharmacy. And there's some PBM tactics that I'm sure you've seen. There's the audit fee, right? These recoveries in a final audit findings for particular PBMs. If it's maybe $10,000 or more, some PBMs assess an additional audit fee. This audit fee may reach up to 20%, right? So it's an arbitrary number that then the PBM will put this in their contract, but this 20% is just kind of thrown out there. It's not connected to the amount of work or the cost of a particular audit. In our experience, it also incentivizes a particular auditor or inspector to try to find more discrepancies to up this audit fee. Is there a real, let's say, we were talking a lot about on-site in, audits or inspections from a board of pharmacy. A PBM does something a lot called a desktop audit, where they don't even enter the pharmacy. They just look through your records. In your claim submissions and your dispensing records, they compare that data from their desk, wherever they're located. And they ask you for a bunch of documents, they sit down, they digest it. And does that really take more time, or does that really cost more? Especially if they're not really on site. It certainly is an arbitrary way to come to a particular dollar amount, but it's something that you really need to be aware of. And the thing that we see the most is they call the fraud, waste, and abuse investigations. So to avoid application of state law protecting pharmacies, PBM often will label audits as fraud, waste, and abuse investigations. And this tactic is, with PBMs, from our experience, is it's a means to bypass fair audit act safeguards, such as prohibitions of recoupment of funds for clerical errors, required appeal timelines, obligations to accept different supporting documents that's submitted by a pharmacy to support a claim. So if a PBM is able to say, well, this isn't an investigation, this is a fraud, waste, and abuse inspection. Like we believe that fraud, waste, and abuse is occurring at this particular pharmacy, so none of these laws will apply. So I rarely see a PBM, if ever, simply call something an audit. Everything's an investigation because it gives them the most leverage to act without any type of safeguards that are afforded to a pharmacy. If you're in the situation where a PBM is threatening termination, PBM concludes that let's say failing to report a board of pharmacy discipline, or they have certain audit discrepancies, and this causes grounds for termination. You've gone through the internal audit process. You got your preliminary audit findings. You appealed those. Maybe the PBM's audit findings were reduced by a few $1,000s. Then there's these final audit findings. Okay, you appeal those, and then the PBM says we're not making any further reductions from the audit discrepancy amount. And guess what? We're also going to provide a notice of termination. So, you know, the, we this is a large part of my practice where I defend pharmacies against these terminations, and there's two kinds that you might see. It's without cause terminations, where a pharmacy where the allegations aren't really identified by the PBM. They just said, well, according to this particular, according to our contract, according to state law, we can terminate without cause. There is the federal any willing provider law, that is a valuable tool to pharmacies. That in some states, if a pharmacy is willing to abide by the reasonable terms and conditions of a contract, the PBM must allow that pharmacy to participate in a particular network. But a lot of PBMs will argue, well, that doesn't apply, that to us. That's more for on the our different insurance carriers, that applies to them, not to us. I've seen it where the next thing I'm going to talk about is with cause terminations, and that can be triggered either from the Board of Pharmacy discipline, audit findings, compliance violations, which is a little more obvious, right? So with cause, as they're saying, well, we're terminating them with cause for these particular reasons. And but I've seen PBMs try to say, all right, we are terminating Larry's pharmacy for these reasons, for these various audit discrepancies, but it's also without cause termination. Okay, it's both. So PBMs will try to have their cake and eat it too at times. And once you get a termination notice, it's really important to look at certain things like, when is the termination going to take effect? You look at the reasons why the PBM is trying to terminate the pharmacy. You'll probably know that a long time before you get the termination notice if you're dealing with preliminary and final audit findings. But it's important to take a look at that. And yeah, if a PBM terminations are alleging fraud, diversion, or imminent patient harm, the other method, they instead of saying we're going to terminate you in 60 days or 90 days, a PBM may try to immediately suspend claim processing, which I see. So they might block pharmacy access to the claim system even. They might freeze payments. You can submit a claim, but you're not getting paid. That's really a de facto immediate termination. But in a situation like that, it's really important to know your rights and to really dive deep into what can you do next. If I can't submit any claims, this is a termination. Do I need to escalate this particular problem? Internal appeal or reconsideration. One thing to do is I've mentioned this, is once you get that termination notice, you can submit a written appeal. It can be 10 or 30 days after a termination notice. And, you're going to want to include a statement of objections, supporting documentation, and the corrective action plan, if applicable. Um, the PBM is most likely going to respond, and the PBM will issue a final determination whether they're going to uphold that determination or not. You know, a pharmacy really has to act quickly after receiving a notice of termination. Make sure you preserve all records. I think at this point, you most likely want to engage counsel. It's possible you can do it on your own, but what are you going to do next, right? So the PBM isn't listening. They are moving forward with a termination. So who's going to make that decision, right? Who's going to make that final call? And the next step could be arbitration or litigation. So there's a bunch of major arbitration associations like the AAA, the American Health Law Association. There's JAMS, or depending on that particular contract, is it going to be litigation? Is it courts, federal or state law? So it's important to understand which venue, if you needed to escalate something, you would need to file either a lawsuit if you're in litigation or an arbitration. So, so what's the difference here, right? So some people say arbitration or court. So arbitration is handled by a private arbitrator. There's not a judge in parentheses there on this slide, but it could be a judge who's no longer sitting at their bench. It could be a former judge, and arbitrators are compensated by the parties directly. Instead of a judge who's being paid by, let's say, tax dollars, the parties actually pay a particular arbitrator to sit on a case. There's, increased privacy though. These arbitrations are not shared with the public like a court, where you could search, let's say, just by searching what is on a particular docket in a court. Limited discovery, so the evidence that's exchanged is most likely going to be less. And it's governed by a different set of rules depending on where you are. Litigation, like we've been saying, has been handled by a judge. Less privacy, more discovery, more evidence exchange. Moves much slower than arbitration. An arbitration could last. It could be different depending on how complex. Let's say 12 to 18 months. Depending on which court you're in, it could be maybe like 3 years or so, 2, 3 years before a case is decided. So it can take a long time for there to be a resolution. If a termination, if you're facing a termination, there's certain claims that you're going to want to consider. It could be breach of contract. The PBM doesn't have a right to terminate the pharmacy and breach the contract. The PBM could have violated certain statutes. There could be a tortious interference with business relationships. And where my practice comes into play is, what I advise clients is, really make an informed decision about whether or not if a client wants to file for a preliminary injunction, and that can be done in arbitration or litigation. A preliminary injunction, or a TRO, which stands for a temporary restraining order, is filed as a method to try to preserve the contractual relationship between a pharmacy and the PBM for the pendency of that litigation or an arbitration. It's an initial method in filing, where if a arbitrator or judge agrees, a pharmacy can stay in network through the duration of a case. And there are some important factors that we need to present. Most importantly, there's a likelihood of success on the merits. These are labor-intensive applications where we present a case to an arbitrator or judge, and we detail why we are likely to succeed. If this case were to go all the way to the end. And also, we need to show that there will be irreparable harm to a particular pharmacy if a termination were to take effect. So they're obviously the higher percentage of the total business for a pharmacy that a PBM represents is more effective to show, hey, if this termination takes effect, this pharmacy is in great danger of having to close its doors. So if you receive a termination notice and a PBM denies your request for any type of reconsideration, it's not the end of the story. It's just the end of the story of you trying to resolve this directly with the PBM. So, but with that, thank you so much for joining us today. We hope you all found this discussion insightful and valuable. If you have any questions or need any additional information, please contact us. All right. We're here to help and support you in navigating these complex issues. Thank you once again for your participation, and I hope everyone has a great day. Thank you.